Please the court, I appear in this matter for the appellant, Mrs Iskandar Safa, with my learned junior, Mr Holden, and my learned friends, Mr Keller, KC, Mr Holland, and Mr Sonecha appear for the respondent, the Republic of Mozambique.
Yes.
As the court will have gathered, this is the hearing of the appellant's appeal against the order of Mr Justice Robin Knowles, dated the 16th of June 2025, whereby he, amongst other things, gave permission to the respondent to amend its re-amended claim form and re-amended consolidated particulars of claim, so as to annex to the particulars of claim a new annex called the joinder POCs. He then joined Mrs Safa along with her two sons, Akram Safa and Alejandro Safa, to the proceedings pursuant to CPR 19.2 and or 19.62, and then also gave permission to serve them out of the jurisdiction pursuant to Practice Direction 6B.
Yes.
Just by way of preliminary, as the court will obviously be aware, having made the order, I think, last week, the only appellant now is Mrs Safa, because her two sons disclaimed their inheritance. And while there was a dispute about the effect of that, pending the issue of a certificate of inheritance by the Lebanese court, after some delay, did issue the certificate of inheritance confirming that disclaimer on the 2nd of June, as a result of which the respondent accepted that the son's appeal should be allowed, and hence an order has been made at the request of the parties, with all other matters such as costs and so on and so forth reserved, allowing that appeal. So we're now solely concerned with the appeal of Mrs Safa. Subject to the court, I was proposing to structure my submissions as follows. First of all, I was going to deal with an introduction and an overview of the issues. Secondly, briefly, general principles relating to, in particular, permission to serve out. Then, thirdly, I was going to address what's been called the enforcement basis for permission to serve out. Then, fourthly, the arguments in relation to what's been called the substantive basis. And then finally, at the conclusion, my learned junior, Mr Holden, is going to address you briefly on the issue of appropriate forum. And to be clear, our arguments in relation to appropriate forum relate only to the substantive basis. We accept that if, contrary to our submissions, the court were to take the view that the judge was entitled to give permission to serve out on the enforcement basis, then we accept the appropriate forum for that must be the English court, because it's inherent in Gateway 3, to put it very briefly.
Yes, well, that seems quite logical.
So to start, first of all, with an introduction and an overview of the issues, generally the background and context for the appeal, material context, is set out in the brief chronology of relevant events, which is in the core bundle, tab 4, at page 76, from which one can gather that the starting point is that the Republic, in about 2019, issued a number of proceedings against, amongst others, the late Mr Safa and some companies in the Prininvest group of companies, who were, I think, defendants 6 to 10 in the proceedings. Precise numbering doesn't matter, but it was the Prininvest group. The Prininvest group was primarily a shipbuilding group of companies. It said in some of the evidence it may be one of the largest private shipbuilding companies, certainly in Europe, possibly in the world. But at all events, Mr Safa was one of the founders of the business, and at the Material Times was either chief executive or chairman of the various businesses. The proceedings, as again you may have gathered, were known by shorthand as the tuna bonds or hidden debt case. and they concerned 3 projects for the provision of tuna fishing fleets and other related facilities for the Republic of Mozambique to enable the economic zone off the coast of Mozambique to be exploited. That's summarised in the first few paragraphs of the judge's main judgment. The Republic, in its claim, alleged that these projects involved corruption in various ways, as a result of which it suffered substantial losses. The various sets of proceedings were consolidated and came on for trial before Mr Justice Robin Knowles in October to December 2023. And Mr Safa, who was at that time gravely ill, gave evidence in those proceedings. Judgment was obviously reserved, and sadly Mr Safa subsequently passed away in January 2024. Shortly prior to the handing down of the main judgment, Mr Justice Robin Knowles made an order relating to the position of Mr Safa, amongst other things, and you'll find the order in the supplementary bundle at tab 4, page 67. And the material part of it is on page 69. Now this will be familiar because the learned judge below quotes it in his judgment below.
Yes.
At the start of the judgment, I think in the second or third paragraph. But as one can see, looking at the order itself, he ruled that the following matters would not be determined in or by the judgment. First, there's all the questions of the consequences of the death of Mr Safa. Those are reserved, called the reserved issues. And then perhaps more importantly for present purposes, 1b, in relation to the claims made against and made by the 12th defendant, the Safa claims, the judgment will state only what the outcome of the determination of the Safa claims would have been had the 12th defendant not died prior to judgment. And then it goes on to deal with other matters such as representatives and so on and so forth.
Yes, so we're not concerned with the position of Mr Akram Azuri?
No, we're not concerned with that. There's further issues about who this should be the representative of the estate and so on and so forth, but those are not material to the appeal.
Right. But there is no English estate or English assets, is that right?
My lord, I'm not sure that's right.
Oh.
There may be some English assets, but more significantly, Mr Azuri was subsequently appointed as the representative for the purpose of the proceedings of the estate. But there is at the moment no personal representative of the estate. There's simply a representative for the purpose of the proceedings. At least that's as far as I'm aware, the current state of play.
Right.
My sense was that there was also someone who had been appointed for the purpose of getting in the English assets. Wasn't that? Maybe I've misunderstood that.
I'm not aware of that.
No, all right, sorry. So
Yeah,
it's
the
just
current-
as a representative for the purposes
Of the proceedings, yes, as far as I'm aware. There was, again, it's a side issue, but one of the issues at the hearing below, before the learned judge, was a dispute about whether or not the family, which is to say Mrs Safa and her 2 sons, could be compulsorily appointed as representatives of the estate for the purposes of the proceedings. And if my recollection serves me right, the Republic abandoned that shortly before the hearing, and therefore I think Mr Azuri was appointed instead to take that position.
I mean, you're using the terminology of the estate. I thought one of the points was that in Lebanese law there is no estate. Or have
That's
I
absolutely right, my
misunderstood
lord.
that?
Sorry, that's right.
So did I misunderstand that? And it's in what sense are you using the term?
It's being used in the sense of the Mr Safa before the English court. There's no difficulty in appointing representatives of Mr Safa's estate for the activities before the English court. Because whether or not the estate has any assets, or whether it's wholly insolvent or whatever the case may be, upon his death, under English law, Mr Safa's estate came into existence and can therefore be represented in the proceedings. So when I'm speaking about the estate, I'm talking really about the procedural steps in England. And your Lordship is quite right, there's no concept of estate in Lebanese law, as is the case in most civil law jurisdictions.
Yes, I see. Thank you.
So that's why I'm talking about the estate. It's the appropriate terminology. And that's why Mr Akram has been appointed to represent the estate of Mr Safa in the current proceedings.
Yes. Right, thank you.
For those purposes. So, following this order, the judgment was handed down on the 28th of July 2024, and as a result of that, again, the judge repeated essentially what's contained in this order in the body of his judgment at paragraphs 33 to 34 of the main judgment. I don't think we need to turn it up because it simply repeats the same terminology. Then the final perhaps step in the story for present purposes, and there have been many other events, but this should do, is the order that a member of the court asked to be produced, I think a couple of days ago, when the court raised the question, has there been any further order following the main judgment? And the answer is there was an order made by the learned judge on the 23rd of December 2024, that was provided or emailed to the court a couple of days ago. I don't know if your Lordship and your Ladyships have it.
It did reach me.
Yes.
It's something called, yes.
It's called a consolidated order, and it's got the seal 23rd of December 2024. And after the various recitals, there's an order. It's an order for judgment on page 2 of the order. It's giving effect to the judgment of the 6th to 10th defendants, which is to say the Prininvest companies are ordered to pay the specified sum by the 2nd of October 2024. So one curiosity, of course, is that this means they were required to do it by a date which had already passed, but I don't think that really matters. And then there's also an order requiring them to indemnify the Republic in respect of certain other matters. And, my lords and my lady, just to tie that up with the judgment itself, you should, I hope, have been provided with an extract of the main judgment, which was sent after the supplemental bundle, again, I think last week. This is the learned judge's main judgment, handed down in July of 2024. And it's quite long, so we've simply taken the first 9 pages and then the last 20 or so pages.
Yes.
I'm going to skip over the first 9 pages and turn to, within the extract, to page 10, which is, say, page 98 of the judgment. And one can see here the judge starts considering the applicable law. He then, on the following pages, goes through the causes of action on the hypotheses that either Mozambican or English law applies, and he then works through each of those and essentially finds the cause of action made out, at the conclusion of which, at page 111 of the judgment, or 23 of the extract, we have paragraph 570, where he concludes that, subject to the balance of the judgment and correction of the figures, Mozambique is entitled as against Mr Safa and the Prininvest companies to payment of the sum set out there, the $825 million, and then to an indemnity in respect to the payments estimated at $1.5 billion, and so on and so forth. The part subject to balance this judgment, the material part of the judgment addressing that, is that he left open the possibility that there might be some credit for recoveries, and you find that in paragraph 600, page 115 of the judgment, 27 of the extract, where, after considering the fact that there had been some recoveries, he says in the middle of that paragraph, I will deal with this aspect as follows. There'll be a credit $421 million against that loss that Mr Safa and Prininvest companies are liable to make good to Mozambique, unless Mozambique applies for an inquiry into the amount of credit that should be allowed, and he'll then consider that application. So essentially, the judgment, subject to some tidying up, finds liability against Mr Safa and the Prininvest companies, treated together as a block, as it were, and also defines the amount and makes provision for the indemnities, and therefore one can see how the order for judgment against the Prininvest companies ties into the findings the judge has made. That may well be there was some further debate about the figures, because I think if you deduct 425 from the figure mentioned in the earlier paragraph, at 570, it doesn't quite match to the amount in the judgment, but nonetheless it's clear that the judgment allows a ready calculation subject to determining the figures of the amounts due and also the order for the indemnity that you see in the order for the
So was Mr Safa's position coextensive with that of the Prininvest companies?
Yes, it was.
So that if he had not died, then the order would simply have included him as the 12th defendant, but would, in all probability, have been exactly the same?
Yes. One can see that, in fact. Again, perhaps we've been over, or I've been over eager with clipping bits out of the judgment and confining the extracts. If you turn back to the first page of the second half, which is page 98 of the judgment, page 10 of the extract, one can see on paragraphs 489 and 490, particularly 489, the answer lies in the facts. I'm satisfied that Mr Safa acted throughout for each and all of the Prininvest companies, in fact the whole Prininvest group, when a promise or payment to Mr Chang was made by one individual or company that was an action on behalf of Mr Safa and all the Prininvest companies, with the knowledge and intent of Mr Safa and all the Prininvest companies. And there are obviously other findings.
So he had no separate liability and no defence, which was not available to them.
That's right, my lord. With that brief preface of the background, I now turn briefly to an overview of the issues on the appeal and to explain why we say that the judge unfortunately fell into error in taking the approach that he did. The respondent argued below, and repeats in argument here, that permission to serve out in joinder is not given and the appellant is not joined. They may then subsequently find it difficult to enforce this judgment in Lebanon or possibly elsewhere. Now, obviously, that is a powerful practical consideration, and it obviously weighed heavily with the learned judge in reaching his conclusion, in particular in relation to the question of appropriate forum. One can see, for example, I don't think we need to turn up, but paragraphs 61 to 64 of his judgment, he expresses his concern about the possibility that the Republic may be left with a judgment that has difficulties of enforcement. However, it is, of course, the case that hard cases make bad law. There is no suggestion that the appellant, Mrs Safa, a bereaved widow, had any knowledge of or involvement in any of the wrongdoing which was found by the judge as against her late husband. She's not a British citizen, she does not live here, and she has no substantial connection with this jurisdiction. It therefore goes without saying that she should not be joined, and indeed cannot be joined to these proceedings, unless the well-known principles applicable to joinder and the obtaining of permission to serve out of the jurisdiction are satisfied.
And she wants to be able to say in any court in the world where this judgment might be sought to be enforced, my husband was not liable to Mozambique. Is that right?
Well, that is possible, my lord.
Right.
But I would not say any certainty about.
That's what this is about, isn't it?
Well, my lord, it's more fundamentally about whether she should be permitted to be joined to these proceedings. What the consequences are of that, or what arguments may be made in other courts, are beyond the scope of the appeal and the debate. And certainly I cannot say what position she will take in any particular proceedings in any court. That will no doubt depend on the advice that she receives in relation to those proceedings in that court.
But so far as the enforcement basis is concerned, and I appreciate there may be different considerations applicable to the substantive basis, that only puts this judgment in the same position as it would have been if Mr Safa had died the day after hand-down instead of in the period between reserving judgment and hand-down.
Well, my lord, neither would make a material difference to the arguments in relation to the application of the what's called the enforcement basis, because as you know, it's our submission that the enforcement basis cannot apply, because by the time the findings were made, following the findings made in relation to Mr Safa, there is no real issue for the court to try between the claimants and the anchor defendant, which is to say, the estate of Mr Safa, and therefore Gateway 3 cannot apply.
Yes, well, that's a point on service, which
Yes, quite so.
come to, certainly.
Yeah, which I will come on to. That's so.
Can I just one question that you said that of the widow that she didn't have any involvement in any wrongdoing of her husband, but as I've understood it, nobody's suggesting that she was implicated in the underlying wrongdoing at all. It's just a matter of enforcing against Safa's assets, to which she succeeded one way or another.
Quite so, my lady. And
So we can leave issues of her wrongdoing to one side, can't we? It's nothing to do with anything.
I was simply making the point, my lady, that therefore we are dealing here with a party who has not been involved in the underlying events. And in order to determine whether that party can be joined and the court can exercise what used to be called its exorbitant jurisdiction to serve her out of the jurisdiction with these proceedings, one needs to be careful to examine the basis on which the service out is founded. And for the reasons I'll expand on in our submission, that in fact there is no basis, no proper basis for service out on either the enforcement or the substantive basis.
Well, you may be right about that, but that's a point on service. But what this appeal is about is it not, is that Mrs Safa would like to inherit the assets without the liability.
Well, my lord, that doesn't follow at all.
No?
No.
All right, why not?
Why not? Because if the courts of Lebanon subsequently decide that the liability in question both exists and can be recognised under the laws of Lebanon, then it will be treated as part of the affairs of the late Mr Safa. I'm using the word affairs instead of the word estate to cover the fact that that's the corpus that moves from the deceased person automatically to the heirs.
So there needs to be a trial in Lebanon of precisely the same issues which were dealt with here.
Well, again, my lord, one cannot assume.
Before Mrs Safa could be held liable on your case.
Again, one cannot assume that. It depends on the law of Lebanon.
Well, you just said, I thought, that if she is held liable in Lebanon.
Yes. We don't have any evidence about precisely what procedure may be taken in order to establish the liability in Lebanon.
Right.
There's an assumption one might have to a retrial, but that may not be so. It depends on what the Court of Lebanon does and the approach it takes in relation to this matter. The state of the evidence is currently that for the purposes of argument, it may not be right, but it's sufficiently arguable, it has been said by at least one of the experts that there's a risk that the English judgment may not be enforceable in Lebanon. That's the state of the evidence. But the evidence goes no further than that. There's no reason to assume that there would necessarily have to be a trial. For all we know, it might be a process of making an application to the Lebanese court in order to see if enforcement can be obtained or not, and so on and so forth. But it might be there would need to be a trial. One simply doesn't know.
Yes.
It's simply that there's a risk of non-enforcement, and that's as far as the point goes.
Okay, thank you.
Or non-recognition. That comes to the same thing. Now, coming back to the overview of the issues I was saying, as Mr Justice Foxton pointed out in the Dubai case, there is no general power to serve proceedings out of the jurisdiction to insist on the enforcement of a judgment, and if there were to be a general power to serve proceedings out of the jurisdiction to assist in the enforcement of an English judgment debt, that would be a matter for the Rules Committee. So it is necessary, for the reasons I've explained, to turn to first principles to consider carefully whether the relevant conditions have been met for joinder and permission to serve out. General principles, turning to my second part of my submissions, are of course very familiar to the court. They were summarised by Lord Collins in the Ultimo Holdings case as being as follows, with service out generally. Firstly, there must be a serious issue to be tried in relation to the underlying claim, again, in relation to which service is sought. Secondly, there has to be a good arguable case that the claim falls within one or more of the jurisdictional gateways under Practice Direction 6b. And thirdly, where one is serving out, the onus lies on the claimant, as it does in relation to the other limbs, to show that England and Wales is clearly or distinctly the most appropriate forum in which to bring the claim. We have also included in the authorities the recent Court of Appeal decision explaining and discussing what is meant by the test of good arguable case. And that is the decision in CAFA and AMS, which you'll find in the authorities bundle at tab 12, page 313. And the relevant passage in this authority is in the judgment of Lord Justice Green, starting on page 332 at paragraph 70, where he was considering the recent pronouncements on this area in the Goldman Sachs case, and also previous to that, the Brownlee case. And the discussion of those continues over those following paragraphs. Now, I don't think I need to spend time on the precise approach to good arguable case. The summary, he's largely concerned with a situation in which there are disputes of facts, and the approach the court should take where there are disputed facts as to whether it can be said that one side, or particularly the claimant, has the better of the argument. And in the present case, we're not in that type of situation where we have disputed issues of fact that cannot be resolved at this stage.
So far as the necessary proper party basis is concerned, we're really concerned with whether there is a real issue to be tried between the claimant, Mozambique, and the anchor defendant, Mr Safa, or the representative now standing in his shoes. Is that right?
Yes, that's right. Nonetheless, the test remains that whichever way one approaches it, the claimant has to show they have the better of the argument. Much has been struck out, so it's simply the better of the argument on the application of the gateway. But the relevant passage is paragraph 70 through to 80, which is currently treated as being the definitive statement as to how one understands the expression good arguable case in this context. I turn now, therefore, to the first ground on which permission to serve out, which is what has come to be called the enforcement basis, although the learned judge didn't use that phrase in this case. It emanates from Mr Justice Jacobs' judgment in the Piffs case, as you probably know.
Yes.
Now, the enforcement basis, as your Lordship has said, is founded only on Gateway 3, which is that by analogy with the Piffs case, there is a real issue between the respondent and the estate of Mr Safa that it's reasonable for the court to try, and that Mrs Safa is a necessary and proper party to that issue. And the learned judge concluded in his judgment at paragraphs 43 to 56, which is in the core bundle at tab 6, page 94. That there was a real issue, his holding being paragraph 48, that the issues between the respondents, or rather the claimants and Mr Safa had not been resolved. One finds that at paragraph 48. And that, therefore, Mr Safa could be considered to be all three respondents in that case. The sons as well could be considered to be necessary and proper parties to that issue. Now, we submit that the learned judge fell into error in this regard in two ways. Firstly, as a starting point, there is in fact no pleaded case by the Republic for service out on the enforcement basis, in contrast to the position in PIFs. And secondly, even if there was, unlike PIFs, there is no real issue extant between the claimants and the anchor defendant, the estate of Mr Safa. I'll take those 2 points in turn. Firstly, as to the question of whether there was a pleaded case on enforcement, I take as my starting point a matter of trite law, which is that one can only obtain permission to serve out of the jurisdiction in relation to a pleaded cause of action. You cannot obtain permission to serve out of the jurisdiction if you haven't pleaded a case which entitles you to service out. It's for that reason, for example, that if you subsequently amend to add another cause of action, you then have to justify that that cause of action too can fall within one of the gateways, otherwise permission to amend will be refused. So one has to focus on whether there is a pleaded case in relation to the enforcement claim. Now, the starting point to determine this is to look first of all at the PIFs case, which is in the authorities bundle, and this is in the Court of Appeal. It's at tab 19.
Can I just ask whether this is a point that was taken before the judge? It doesn't appear from his judgment, I don't think.
Well, my lord, the answer to that is that the case wasn't argued on an enforcement basis before the judge in any distinct way. It was simply argued on the basis of the pleaded case. And as one of the arguments, the Republic asserted that they needed to have joinder in order to be able to avoid the risk of the judgment being unenforceable. So it was one of the arguments put forward on the basis of the claim as pleaded. The reason for that is that the Mr Justice Jacobs judgment, which can clearly distinguished between what became called the enforcement basis and the substantive basis, was handed down subsequently to the argument in our case, but before the judge gave his reserved judgment.
But there was an opportunity to put in submissions, wasn't there?
There was an opportunity to put in
Which you
submissions.
took. And was the point taken in those submissions?
That I can't recall, my lord. I'd have to check. I think the submissions are in the supplemental bundle. The Safa family submissions on PIFs are at tab 11.2, page 196 in the supplemental bundle.
it looks as if you took essentially 2 points reading this very quickly. One is that Mr Justice Jacobs was wrong, well that's no longer of any use to you.
Yeah.
And that it was different because he was joining before the trial, and here the trial had already happened. That's your final paragraph 10, I think.
Yes. And I suspect, my lords, again, sorry, I'm just doing this on my feet, I hadn't looked at this particular point. It may well be because the first instance decision in PIFs, unlike the Court of Appeal decision, did not quote pleading, simply discussed the matter. The first instance decision in PIFs is at tab 18, page 473. And Mr Justice Jacobs, after referring to Swiss law, paragraph 10, explains PIF's decision. There are two reasons why the heirs are proper parties. And then he summarises the argument. Pursuant to Swiss law, PIFs has a claim to avoid the risk of an outcome whereby, following a very substantial trial, etc. And he then refers to the experts' reports on Swiss law. And then goes on to deal with submissions. Yes. At that time, my lord, we didn't have a quotation of the PIF's pleading, so we could not in fact see the fact that the enforcement basis had been pleaded. So we were addressing the reasoning in Mr Justice Jacobs' argument. However, if you turn to the next tab, which is PIFs in the Court of Appeal, that's tab 19, at paragraph 17, Lord Justice Arnold quotes PIF's pleaded case. This is page 601. One can see that under A, there is a substantive basis, which is the claim we say that is pleaded in this case, the equivalent of it. Mr Al-Rajan was domiciled in Switzerland when he died. The administration of state governed by Swiss law is correct. PIFs is entitled to win claims against the Al-Rajan heirs on the basis of the other statutory heirs of Mr Al-Rajan. And then B, further alternatively, and this is the enforcement basis, regardless of whether Mr Al-Rajan was domiciled in Switzerland when he died, PIFs claims against the Al-Rajan heirs to ensure it obtains effective remedies in circumstances where Swiss law applies to issues of succession, and the heirs are joined to ensure that PIFs obtains effective remedies against any such assets. Mr Al-Rajan was domiciled in England. The Swiss court would apply English law to issues of succession. Mr Al-Rajan held assets in different jurisdictions at the time of his death, and other jurisdictions that may hold some or all of those assets, etc., where an enforceable judgment against those assets in relation to Al-Rajan's liabilities depends or may depend on judgment having been entered as against the Al-Rajan heirs. So that is the pleading in the PIF's case. By way of contrast, in the present case, in the joinder particulars of claim, at tab 9, there is, we submit, no pleading of an enforcement claim, only a substantive claim. Sorry, it's page 105 of the core bundle. we see the Republic's claims against the Safa heirs explain that Mr Safa died intestate, was a non-Muslim. Last place of domicile was Lebanon, that's paragraph 6. And then the succession, paragraph 8, to Mr Safa's liabilities is governed by Lebanese law. As a matter of Lebanese law, deceased legal identity ceases to exist. Then various articles of the Lebanese Code of Obligations and Contracts and inheritance law are pleaded, the effect of which it is alleged is the deceased assets, debts and liabilities transfer automatically and immediately to the heirs de jure, subject to the limits referred to in the paragraphs below. And then they plead that the heirs are spouse and children, and then refers to various further provisions. And at 9.5, general principle of Lebanese law, the obligations and liabilities of the deceased transfer in their entirety to the heirs. However, heirs are only liable in respect of and up to their respective share of the hereditary debts and liabilities. And as a matter of doctrine, the total financial liability of each heir is limited. Then at paragraph 10, we come to the consequence of those pleadings, which is in the premises. Firstly, it's alleged the Safa heirs are the heirs to Mr Safa. Secondly, upon Mr Safa's death, the Safa heirs together succeeded to the assets and liabilities of Mr Safa, and they're each liable, as set out there, up to their respective shares. Thirdly, Mr Safa is liable to the Republic for the reasons and the amounts pleaded in the POC. In the further premises, the Safa heirs have succeeded to Mr Safa's liabilities to the Republic and are liable to the Republic in the same manner, to the same extent as Mr Safa.
Why isn't paragraph 10.3 a pleading as against the heirs, or now as against Mrs Safa only, of the enforcement basis? It's saying
that is a necessary step in the pleading of the substantive basis, but it's not a plea, as one sees in the PIF's case, of the enforcement basis. In the PIF's case, one can see that the necessary facts to justify an enforcement basis claim are laid out. Specifically, if one goes back to the authorities bundle at 601, A is the substantive basis, B is the enforcement basis, and various particular facts and matters are laid out or asserted to justify the enforcement basis. There is nothing, however, by contrast in the joinder particulars of claim that pleads that there's a need to join the heirs in order to ensure the enforceability of the judgment. It's simply not there, because that's not the claim that's been pleaded. It's a straightforward substantive basis claim. Obviously, as a necessary part.
You don't usually, in a particulars of claim, explain why you need to join the defendant. You just say, here are the facts, and this is what I claim to be entitled against the defendant.
I entirely agree, my lord. But nonetheless, you do need to plead the basis or the facts which would justify the relevant joinder. In the present case, to justify an enforcement basis, you need to plead the facts and matters that justify that basis. And they are not in the joinder particulars of claim. It's a straightforward substantive claim. The plea in paragraph 10.3 is simply part of the necessary steps to establish the substantive basis. There's no suggestion that it's required as a matter of Swiss or Lebanese law or any other system of law to join the heirs in order to make the judgment enforceable, which is what one finds in the PIF's case. And that's why, in the PIF's case, the Court of Appeal was able to identify the two different bases as substantive and enforcement.
So what is missing from our pleading then is a statement that it is necessary to join Mrs Safa in order to make the judgment enforceable in Lebanon or wherever else it may be.
Yes. What's missing is the equivalent of paragraph B on page 601 of the PIF's judgment, where the plea is quoted. To ensure it obtains an effective remedy in circumstances where, and then the circumstances are pleaded.
It might be thought this is rather an unreal submission, because the whole point of this application was to try to overcome possible hurdles to enforcement in Lebanon. They're not doing it for nothing.
Well,
And there was evidence which suggested that then, among other things, if they weren't joined, there might be a risk that there'd be a need for relitigation.
And that
It's
was
self-evident why it's being done.
certainly one of the arguments made, my lord, but nonetheless, and I've made the point now, I'm not going to labour it further. Nonetheless, when you're seeking permission to serve out, you need to plead the cause of action on which you rely in order to obtain permission and to be able to argue that one of the gateways applies. But I've made the point, it's a short point, and I need to say no more about it at this stage. I turn now to the second point, which is this. In order for Gateway 3 to apply, it is necessary that there should be a real issue between the anchor defendant and the claimant, which it's reasonable for the court to try, and that the proposed new defendant is necessary or desirable to be added for the purpose of resolving that same issue. There's no real dispute about the correct approach to Gateway 3, as I understand it. And the text of Gateway 3 is quoted in our skeleton and also in the judgment itself of the learned judge below. It's, for example, quoted in paragraph 43 of the learned judge's judgment, page 94 of the core bundle, tab 6. And I'm sure we've all read it many times, and the effect of it is not really in dispute. Claim is made against a person, the defendant, on whom the claim form has been or will be served, otherwise than in reliance on this paragraph, and A, there is between the claimant and the defendant a real issue, which is reasonable for the court to try, and B, the claimant wishes to serve the claim form on another person who is a necessary or proper party to that claim. So the short point that arises in this case is it correct, as the respondents argue, to say that this case is indistinguishable from PIFs, because it's clear from binding authority in PIFs in the Court of Appeal that this gateway would apply in very closely analogous circumstances where the joinder is sought prior to trial, because at that point in PIFs, the heirs were being joined at a stage where they could participate in the trial if they chose to do so, that the liability of the deceased had not been determined, and therefore that was the common issue that existed. The real issue the court needed to try between the anchor defendant and the estate of the deceased was whether the deceased was liable as alleged, and that same issue arose as between the deceased and the deceased, or the claimant and the heirs. So that was the situation in PIFs. In the present case, the question is there a real issue which the court needs to, which is reasonable for the court to try in circumstances where, as we've seen, the trial has already taken place and findings have been made concerning Mr Safa, which would give rise, were the claimants to choose to do so, to a judgment in a similar form, perhaps the identical form, subject to alterations for the fact it's Mr Safa's estate, to the form of the judgment made in December 2024 against the Prinivest companies. That question is answered by looking at the authorities which discuss what is a real issue. The starting point is the Erste Group Bank case, a decision of this court, which is in the authorities at tab 8, page 189. As one can see from the headnote, this was a case on page 189. The claimant Erste is a London bank, branch of an Austrian bank, and it was seeking to make claims against a Russian company, first defendant, under a loan agreement which was guaranteed by its parent, the second defendant. And the third defendant was a state corporation, the fifth was a wholly owned subsidiary. the bank's case was defendants were all part of a conspiracy to put the assets of D1 and D2 out of reach by hiving down their assets to another subsidiary, D7. D1 defaulted, D1 and D2 were then subject to insolvency procedures in Russia. The bank obtained summary judgment against D1 and D2 on its debt and contractual claims. That's on page 707 at B. And then applied for permission to serve the proceedings out on other defendants. And D3 and D5 challenged the jurisdiction. And the court held, applying whether there was a real issue to be tried, there was not a real issue anymore to be tried between the anchor defendants and the claimant, and accordingly, permission to serve out was set aside. And the body of the judgment, the relevant parts are at paragraph 78, which is on page 221. And the court summarises its conclusions. Lady Justice Gloucester, at paragraph 78. Our reasons for this conclusion summarised as follows. In Roman 1, as between the bank and D1, there was at the date of the application before Cook J no real issue at all as to the bank's entitlement to its debt and contractual claims under the loan agreement. Claims have been admitted to the list of creditors of D1 pursuant to an order, and talk about the bank participating in creditors' meetings. Although the bank's evidence in support of the application for permission to serve out the jurisdiction showed that D1 was well aware of the proceedings, there was no suggestion such evidence D1 was disputing indebtedness under the loan agreement on any grounds, substantive or otherwise. Nor was there any suggestion such evidence there were real issues to be tried between the bank and D1 in relation to the debt and contractual claims, which is reasonable for the court to try. And then at 2, as at the date of the application to serve out, D1 and D2 had both failed to file an acknowledgement of service, otherwise indicated they intended to defend the proceedings. Consequently, as at that date, the bank was entitled to obtain or apply for judgment against both D1 and D2 in default of acknowledgement of service under CPR Part 12. And therefore, at 4, in such circumstances, the date of the application, no real issue between the bank and D1 in relation to the debt and contractual claims under the loan agreement. Certainly none of it was reasonable for the court to try. And to similar effect, at paragraph 136, the court says, for the reasons we have already given above in the context of consideration of paragraph 3.13 gateway, it's unrealistic to suppose, even at the date of the application before Cook J, that there was ever going to be a trial in England on the merits based on evidence of the conspiracy claims as against D1, D2, and D7. And they go on to refer to the other facts, such as insolvency procedures and lack of filing of acknowledgement of services, and so on and so forth. It's our submission that the decision in Erste clearly draws the line between when there is a real issue and when there isn't. There's no real issue if there is going to be no case to try, and if the proposed anchor defendant is not going to be in a position to resist any application for judgment. Simply no issue remaining. And it's our submission that that is precisely the situation here, as between the claimants and the estate of Mr Safa. The claimants have all the findings in the main judgment. All they need to do is simply apply, as against the estate, for an order for judgment in the same terms as the order they obtained against the Prinovest companies, and for the same reason. My Lord, it's a mystery as to why they haven't done it already or didn't do it at the same time. One suspects they haven't done it simply because it would not assist them in their argument in relation to the joinder of Mrs. Safa, were they to step forward and obtain the judgment which they are undoubtedly entitled to obtain on the basis of the findings made in the main judgment as against Mr. Safa.
What, if any, ancillary matters would remain to be determined? The judge has already dealt with interest and costs against the Privinvest companies, would there be different arguments for Mr Safa?
I cannot say, my lord, I can only speculate. There may or may not be other arguments regarding Mr Safa, and perhaps they'd be arguing about interest. Difficult to see why the interest should be any different, given that the claim is the same, and the interest calculations have presumably been either threshed out or agreed, and then recorded in the order, and are essentially a matter of mathematics in determining the correct rate to apply to the relevant currency during the relevant periods. As for costs, I cannot say whether there be different arguments. It's not easy to see why Mr Safa's estate would necessarily be in a different position to the Privinvest companies, but I wasn't involved at all in the previous trial, and so I'm afraid I cannot say. It's possible, but even if that were the case, there isn't a real issue to try as between the anchor defendant and the claimant. If that were so, then the Erskine decision would be very different, because one could always say, well, there might be an argument about calculation of interest or cost. The point in the Erskine case is that essentially if the claimant is in a position to apply for or obtain judgment, one cannot say there's a real issue. And this case is indistinguishable from Erskine as a matter of principle.
Can I just ask this, is there any authority dealing with what happens if there's an appeal against a judgment that you're aware of? How does it work in that sort of case?
I'm not aware of any authority, my lord.
How do you say it would work?
Well, in the present case, the answer is that's fairly simple, which is that whether a claimant is entitled to obtain permission to serve out is said in Erskine, but in many other cases, is determined as at the date of the application for permission. If, as at the date of an application for permission, a party is entitled to obtain judgment for whatever reason, because they've got summary judgment, etc., whatever the case may be, the findings are already made, then that is the basis on which the court proceeds at that time as to whether there's a real issue. And the answer may be there is no real issue. If there's an outstanding appeal, at that time there is no real issue. If the appeal then succeeds, the position may then be different.
But you can't, then it's too late on your argument because there isn't an issue. What about the position where there's a judgment and a party says, right, I'm going to appeal that, which may mean that the whole thing goes, and the other party, say the judgment creditor, then says, well, I want to join someone else in order to make sure that they're bound. How does that work?
Well, the judgment creditor may have to wait until the appeal is resolved, because, as I say, the question of whether there is a real issue is determined as at the date of the application for permission to serve out.
But as I say, that seems on your argument to be too late, because then the appeal is resolved, and that's an end of it. So there wouldn't be anything left to.
But if the appeal fails,
there'd be no issues left.
Sorry, my lord, I didn't mean to interrupt. If the appeal fails, then there never was an issue. The position is the same as at the moment the application was made. If the appeal succeeds, then the position is different, and there may then be real issues following the appeal between the anchor defendant and the original defendant. It's reasonable for the court to determine.
But if the appeal fails, there's nothing left then for the court to decide. It's then too late to join in anybody else, isn't it?
It is, yes, my lord, because then there was an issue. The position has not changed as a result of the appeal.
But in the period when the appeal is pending, there was an issue, wasn't there?
Well, no, my lord, that's the point. There isn't an issue because the findings are final, again, on the basic principle of issue estoppel. At the time that the findings are made, the findings are final up until they are changed on appeal. They continue to be binding as between the parties unless and until they are changed on appeal. So one considers whether there's an issue at the time of the application. And if there's an appeal, well, it doesn't change the fact that there are findings.
Was there, in fact, an appeal by anybody
Yes,
on the main judgment? And
there
what
was an
happened to it?
appeal. The Prininvest companies applied for and obtained permission to appeal. Just check my notes as to the details of this. They applied for and obtained permission to appeal. The appeal was then made subject to the provision of very substantial security in, I think, the sum of 13.5 million. The Safa family provided security in the form of equitable charges over some property. That was subsequently held to be insufficient security, not satisfactory security for the purposes of the order. And Lord Justice Phillips then made an unless order that the amount of 13.5 million should be provided by the 6th of May this year. The money wasn't provided. There was a one-day extension to the 7th of May. The money wasn't provided by the final date originally or was extended, and therefore the appeal was automatically dismissed for failure to comply with the condition. And the Safa family subsequently made an application for relief from sanctions or for relief in relation to that, which was also refused. It was the corporate defendants who made the application. Yes, they were subject to the condition. So it was them who made the application. So the appeal is at an end by the Prininvest companies.
Thank you.
But it was still in existence at the time of this decision that we're looking at.
That would depend on the timing, my lord. I can probably confirm that by looking at the dates. I cannot at the moment recall exactly when permission to appeal was granted, but I can check and come back on that.
You corrected yourself on who made the application for relief from sanctions, I think,
Yes.
but it was still the Safa family who provided the security which was held to be insufficient.
That's right, my lord. Yes. Now, turning, as I say, I was on the subject of what is a real issue to be tried, and for the reasons I have explained, in our submission, there is no real issue because the position is on all fours with the position as described in the Erste Bank case. All the findings have been made, and that is essentially the end of the matter as between the Republic and the estate of Mr Safa, which is the anchor defendant for these purposes. Now, we engaged in some correspondence in order to see if we could understand what the Republic's position was in relation to the effect of the findings in the main judgment as against Mr Safa. You'll find that correspondence in tabs 16 to 20 of the supplemental bundle. Sorry, 15, I should say. The first letter. That's at page 240. And as one can see, my instructing solicitors wrote to the Republic's instructing solicitors on the 2nd of April in relation to the skeleton, saying we consider it to be helpful for the client to clarify its position on one particular issue. In seeking to rely on PIF's CA, your client contends, in summary, the claims against Mr Safa were not determined, and accordingly, as in PIF's CA, our clients are necessary and proper parties to enable the issue of the deceased liability to the claimant to be determined as between the claimant and the heirs. And we then make the point that the trial has taken place and that the heirs did not take any part in the trial, unlike the defendants in PIF's. In these circumstances, don't understand the basis on which it's argued the respondent's skeleton, the issue of Mr Safa's liability to the property has not been determined. Is it your client's position that the findings against Mr Safa do not create issue estoppels so that it would be open to our clients, if they remain joined, to reopen the trial and contest the findings? If not, what is the issue that remains open to our clients to contest? So in other words, we were seeking an answer as to whether, as one would assume to be the case, it was the Republic's position that the effect of the judgment, although not yet embodied in an order for judgment, was to create issue estoppels, which the family would not be able to contest were they to be joined. And the short answer is that although we sought answers to that question a number of times, it wasn't answered. The Republic simply, if one looks at tab 16, page 242, referred back to the reservations made by the learned judge in his judgment on the order. We raised the question again on 245, and after a chaser at tab 19 at 248, at paragraph 3 at 249, tab 20, the Republic's position is that its position is clear, does not require further explanation.
Did the judge identify the real issue which it was reasonable for the court to try in his judgment?
I think he did, my lord, yes. There's a paragraph where he... It's paragraph 48 of the judgment, core bundle, tab 6, page 95. And he records our submissions. Paragraph 45, the first point is we say that there's no issue because all the issues have been tried. So that's the point I'm submitting in relation to now. And then we secondly argue it wasn't the same issue. And paragraph 47, he rejects both the points. As the first, on Mr Safa's death before judgment, although the trial had been concluded, the issues had not been determined. There is no judgment as things stand against Mr Safa or the respondents. So that's what he finds in relation to that. Now, with respect, we say that the learned judge fell into error in making that conclusion because he's confusing the question of whether a judgment has formally been entered with the question of whether there are actually any issues extant between the claimant and the estate of Mr Safa, which it's reasonable for the court to try, to which the answer is no, there aren't. And the way that one can test that is by asking the question, well, if the family are joined, can they challenge the findings made in relation to Mr Safa? To which the answer is no. They are conclusively determined as between Mr Safa and will no doubt bind his estate as well. And so in those circumstances, there isn't an issue. In short, the Republic can't have it both ways. It cannot both say, well, there's a real issue as to Mr Safa's liability, which it's reasonable for the court to try, and at the same time say, but in fact, the family can't challenge it. And that's what the correspondence was directed to, seeing if we could elucidate whether the Republic was saying that it was open to the family, if it chose to do so, to challenge those findings. One assumes that it's their position that it's not, in which case there is no real issue. And indeed, we don't dispute that it's probably not open to the family to dispute, would not be open to Mrs. Safa to dispute the findings, because clearly, after a long trial, there's been a judgment and a number of findings have been made. Even if the findings are not yet embodied in an order for judgment, they create issue estoppels after a contested hearing. Which
is that on the basis of privity of interest?
Between the estate and Mr Safa?
Between Mr Safa, who's still being treated as a defendant for the purposes of the proceedings, albeit represented, and your client?
It's not on the basis of privity of interest, my lord. It's that if Mrs Safa were joined to the proceedings, considering the matter both practically and legally, would it be open to her to say, I dispute the findings against Mr Safa? Indeed, she does not agree with them, but that's a different matter. But it would not be open to her then to say, we need to have a trial.
If she's joined?
If she's joined.
If she isn't joined, what would be the position? Would she still be bound as the heir of the person who's been found liable? In England, in English law?
In English law, the estate would be bound, and that would have consequences for the heir. But the heir is a non-party and is therefore
well, that's when there's
consequences of the...
Sorry. Sorry.
The consequence, my lord, it's a good point, but the consequences of the findings as against the estate may have results for the heir, but it would not be open if one simply moved all of the facts of this to England. It would not be open in any case for an heir to an estate to challenge the findings as against the estate simply because they didn't agree with them and because they were affected by the findings but were not parties to the proceedings, because they're not the relevant party. They're not the party against whom the liability is directed.
Well, that's the question. Would they be bound, even though they're not a party?
They would not be bound by the findings, but they would not be able to challenge the findings as against the estate. So suppose you have an heir and the estate is found to be liable to pay £1 million to some creditor. The heir could not, following a judgment for £1 million, seek to unravel the judgment because they were affected by it. They're not a party.
So they would, in practice, be bound by it.
Well, in the same way as any third party is affected by a judgment against another person, if they might have an interest in the person or in the proceeds. They're not bound by it, but they're affected by it. It's binding as between the parties. It's not binding as regards.
Well, they wouldn't be able to challenge it in a legal
They wouldn't be able to challenge it.
So that it is binding.
Oh, my lord, it may be that we're at cross purposes about the wording. I generally would take the view that where A and B, there's a judgment between A and B which concludes that B owes A an amount of money, then it's binding as between those parties and B must pay the money from his resources. One wouldn't ordinarily say that it's binding against non-parties, but non-parties can't challenge the decision on liability between A and B.
Well, they can't if there's privity if they're privies. That's really what I'm asking about. So there's a series of, there's obviously a large body of law on this, but the decision is binding not only on B, but on B's privies.
Oh,
and the question I'm asking is whether, for this purpose, at least as a matter of English law, your client would be a privy of Mr Safa,
as a
so
matter
that a decision against him that he was liable to the claimant was something which would be binding, would create an estoppel as against your client.
I understand the point, my lord. You're referring to a situation where the issue estoppel is itself binding on the party, rather than simply one the party can't challenge because he wasn't party to the proceedings and it's been determined. Well, in those circumstances, my lord, no, under English law, an heir is not a privy, as I understand it. I haven't looked at the point. But privies for these purposes are people who are successors or have stepped into the shoes in one way or another of the rights of the party to the litigation. So,
Well, a person can be, I mean, maybe this is a cul-de-sac, but a person can be a privy for the purpose of being bound just as much as a person can be a privy for the purpose of having a claim. In other words, it works both ways.
yes, but in either case, it arises in circumstances where the person is subrogated to or succeeds to the rights of the party who is either bound by or seeking to take advantage of the finding, or an assignee, for example. It's circumstances where the privy is someone who is deriving their rights through the party who was party to the proceedings. An heir to an estate in England is not a privy to the estate. They're simply someone who may benefit from the distribution from the estate when the estate's affairs are resolved. They're not privies of the estate as such. They're independent third parties who may receive a distribution or may not. So in these circumstances, under English law, my lord, the answer to your question is no. Mrs. Safa.
Well, that assumes, sorry, I don't want to spend too long on this,
No.
that assumes that the estate is one which is administered here. I'm talking about a situation of an heir where there isn't that form of administration, but nonetheless one's dealing with an English judgment. And I wondered whether there's any authority on what position of an heir is, whether I quite accept that where you have the administration of an estate in England, then it's dealt with differently, but where heirs are concerned, which arises under many systems of law, is there any English authority on whether the heir is treated as privy to the claim against the deceased.
I'm not aware of any authority, my lord, which is to say, I can't be sure that it doesn't exist, but I'm not aware of any authority. It may be that we can see if we can find out whether there's authority on that particular point.
There may be a distinction between the position of an heir under the civil law system, which seems to be broadly similar in lots of jurisdictions, and somebody else, such as another creditor of the deceased, who would not be able to challenge the judgment. The judgment would conclusively establish that the deceased had whatever liability was found to exist, but the other creditor wouldn't be regarded as a privy in the same way that an heir might be.
Yes, quite so. There is a further complication, of course, my lord, which is that if one moves the facts to a civil law system, such as Lebanon or France, or the other one, Switzerland, that we have seen, where there is no concept of a separate estate, there's simply the person ceases to exist and their affairs become vested automatically, subject to various conditions and so on and so forth in the heir. If the issue is whether or not the liability attaches to the estate, that we submit, as I'm going to come on to shortly, is a matter for administration, which would then be determined by the foreign court. And therefore, it may be that there are few authorities considering this from the English point of view, because that would involve making a determination as to the extent to which the foreign estate, in inverted commas, was able to, or had inherited or stepped into the shoes of the deceased. So it may be that it's something that falls outside the parameters of what the English court will be prepared to decide. At all events, the point is simply this: in our submission, there is no real issue, and therefore Gateway 3 can't apply. My lords, this may be a convenient, my lady, this may be a convenient moment to pick up the authority that the court sent us this morning, which bears little on this point, although it's to do with CPR 19.2, but it has, by analogy, some application here. This is the Hotel Portofino Portfolio 2 case. It's a decision of Mr Justice Foxton, as he then was, in 2022. And I don't know if your lordship and your lady have a copy of this.
Do you have any spares?
Sorry?
Do you have any spares?
We do have some spares.
I'm grateful, thank you.
Yes, I've got one, so I will.
It was sent to us by the court, and it may have passed several members by. It's a judgment to do with consequential matters following an earlier judgment, and he summarises the various topics for consideration in paragraph 1, declarations and so on and so forth. But the second topic, under Roman 2, is HP2's application to join Grendo investments to the judgment for the purpose of binding Grendo to the findings in the judgment under CPR 19.2. Then there are other issues he lists. He goes to consider that issue on page 10 of the judgment. Should Grendo be joined? He refers to CPR 19.2 and sets out 19.2 and notes that CPR 19.2 can be used to join parties to proceedings after judgment has been handed down, and then refers to the Dunwoody marketing case, which is one of the ones that my learned friends rely on for this proposition, an order for joinder made after judgment, etc. And he also explains in paragraph 24 it's been applied to join a defendant to proceedings which is settled on the basis of a Tomlin order for purpose of court proceedings, to join a third party to proceedings in which judgment has already been given for the purpose of determining certain issues. Pausing there, my lords and my lady, of course, 19.2 is broader than Gateway 3 because it doesn't have the requirement of real issue, and therefore to some extent 19.2 is a necessary but not sufficient condition for the claimants to establish in order to be able to get permission to serve out, because they have to go further and satisfy Gateway 2, which has the particular requirement that I have already made submissions about concerning real issue. However, moving on with this decision, it does have something useful to say about the reason why joinder may not be allowed after judgment in paragraph 25. However, the purpose of the proposed joinder in all of these cases is essentially forward-looking, to allow the new party to enforce relief granted if it succeeded to the rights of the former claimant, or to allow a new party to be bound by and have the opportunity to be heard in relation to matters which had yet to be determined, but which would arise in post-judgment proceedings. By contrast, the purpose of the joinder application in this case is essentially backward-looking, to bind Grender to findings which have already been made in proceedings in which it was not a participant and did not have an opportunity to be heard. That appears to involve a very different situation to those previously considered. The general rule is that only parties to litigation are bound by determinations made in it, and he then quotes from Sales J, as he then was in Seven Arts. The basic rule is before a person is to be bound by a judgment, fairness requires you to be joined as a party in the proceedings to have procedural protections that carries with it. Importance of the general rule and fundamental importance of the principle of fair treatment to which it gives expression indicates the narrowness of the exception to the rule. It would be surprising if the strict test for determining whether someone was privy in interest to a party litigation could be circumvented by joining them to the proceedings after trial. And it's not necessary in this case to join a new party. It would be appropriate to join a new party proceedings after judgment for such a purpose in circumstances in which the new party was not a successor in title or privy in interest in the existing party. Even if there was such a jurisdiction, it must be a very rare case where it would be appropriate to exercise it. There are two reasons why it would be particularly inappropriate to make in the present case, and it goes on to address the particular case in hand. The point of that is it illustrates the argument that we have been making, which is that if, as we say, all the issues between the late Mr Safa and the Republic have been determined and is not open to Mrs Safa, even if she were joined to contest them, that is not an appropriate circumstance in which to join her. The reasoning in PIFs was exactly to the contrary. The reason why it was fair and reasonable to join the family at that stage was because the trial was about to take place, and therefore they'd have an opportunity to contest the matters if they wanted to. The opposite is the case here, and therefore the reasoning in this case squarely applies to our case here. It's not appropriate to join a party once the shouting's over and it's all said and done, and they have no opportunity to contest the issue which they're alleged to be joined to address. Finally, on this topic, I have two brief further arguments made by the respondent in relation to this. The first is the respondent has based arguments on cases relating to joinder under CPR 19.2. One finds that, for example, in the respondent's skeleton at paragraph 33.2, which is in the core bundle at tab 3.2, page 60. And one can see there that the respondents are relying on Pablo Starr and Dunwoody Sports Marketing, which are cases about joinder post-judgment. 2 points in relation to that. Firstly, as we have seen, joinder post-judgment is very rarely appropriate in circumstances where the party in question has had no opportunity to contest the original issues that led to the judgment. But also, secondly, more broadly, CPR 19.2 is a much broader jurisdiction and doesn't have the real issue requirement that one finds in Gateway 3. So it's really neither here nor there. The court does have power sometimes to join parties to proceedings post-judgment. It doesn't explain what the position is if post-judgment someone tries to rely on Gateway 3. In those circumstances, the reasons we've explained, there is no real issue, and therefore Gateway 3 can't be relied on.
just ask this. Do you accept that if you look at Gateway 3, it's got two requirements. It's got A and B. Do you accept that B is essentially the same as the rule on joinder in Rule 19? Is it just a...
Yes, it is.
So the cases that we've just been looking at are all about 3B?
Yes. They are. The cases say, I think we referred to it in our skeleton at various points, but the authorities are clear that if you satisfy the necessary requirements of Gateway 3, the real issue, reasonable for the court to try, then the discretionary question, which is, is it desirable to join the defendant, is treated as if the parties were all in England. You imagine it was all in England once you got past the A requirement. You then determine B as if it were simply an English joinder case.
And it doesn't look as though Mr Justice Foxton, we haven't looked at this Pablo Starr case, but I don't think he refers to that. But he does refer to Dunwoody. Anyway.
Pablo Starr is at tab 10 of the authorities. At page 277. It arises out, as one can see from the head note, it's to do with an application for a company to be restored to the register. Context may not matter. The highlighted passage is on page 288. And this is Sir Terence Etherton, MR. And the highlighted passage is 50 to 52. On its literal wording, directed to a situation where prior to joinder there's already existed a dispute. In the present case, aside from the issues Welsh ministers wish to raise, there's not never been, strictly speaking, any dispute. And then so on and so forth. Provisions of CPR 1922 ought, however, to give a wide interpretation. The words in dispute ought to be read as in issue. And then he refers to Dunwoody marketing, sports marketing. So again, as one can see, the authorities considering 19.2 are different to the authorities considering the question whether there's a real issue that it's reasonable. Different point. I now turn, therefore, to the substantive basis, claim made on the substantive basis. And again, one applies the three conditions. The first is there must be a serious issue to be tried. Secondly, there must be a good arguable case that one or more of the gateways apply. And thirdly, in this context, one has to be satisfied that England is clearly or distinctly the most appropriate forum. The learned judge decided that all three were satisfied, and it's our submission that he fell into error in relation to all three. Because, firstly, in relation to the serious issue, there is no serious issue because the proposed claim is not subject to the jurisdiction of the English court in accordance with long-standing principles of private international law. Secondly, even if we're wrong about that, there's no good arguable case that any gateway applies. And then finally, which my learned junior will deal with, in any case, even if the other two could be satisfied, England is plainly not the appropriate forum, and the judge fell into error in his evaluation of that issue. I therefore turn to the first requirement, which is the serious issue to be tried. The starting point under this heading, first of all, is that the English court will not accept jurisdiction over claims against a person acting as the administrator of a foreign estate in that capacity, which are a matter exclusively for the courts of that country. And this is a well-established principle. We've cited a number of authorities which apply it, and also it's summarised in Dicey at Rule 160, which is in the bundle of authorities at page 629. That's tab 20. And Rule 160 is set out there. The foreign personal representative is not, as such, under any liability in England and cannot, as foreign personal representative, be sued in England. And then the comment repeats essentially the rule. A foreign personal representative cannot be made liable in England for property held or act done by him or her in his or her character of foreign administrator. And that rule has been adopted by, but also derives from a number of authorities, which we've also cited in our skeleton. The first is Nova and Grove, which is at tab 2 of the authorities bundle, and it's a decision of the Court of Appeal of Alberta. And one finds the relevant passage in this related to an action being brought against a Texan executor who disputed that the Albertan courts had jurisdiction. Page 25 of the authorities bundle said there is considerable authority for the position taken by the Texas executor. He may not be sued in Alberta. Then they refer to Williams and Mortimer, unless he can be sued in executor de son tort, or unless he has obtained a grant of probate or letter of administration in this country, a foreign personal representative cannot be sued in his official capacity in this country. And then authorities are cited for that. Similarly, Dicey and Morris, Conflicts of Laws, Rule 95, and this was Rule 95 at that time, it's now Rule 160. Again, the same point. Foreign personal representative is not, as such, under any liability, and cannot a foreign personal representative be sued in England. And then they refer to Shannon Montreal Trust, Ontario Court of Appeal. Broadly speaking, this is trite law. And on paragraph 29, again, the highlighted passages to the same effect. Similarly, in the English authority of Degazin and Barclays, which is the next tab, tab 3, page 33, this is an action by Mr Degazin, who was seeking to recover fees for legal services rendered in the Commonwealth of Dominica, West Indies, to a former client. And he was acting as the administrator of the estate in Dominica. And turning to the highlighted passage, again, the court concluded and applied the principle that a foreign administrator could not be sued, because Barclays was the administrator in the foreign jurisdiction. Starting in the last paragraph on page 36, I then come finally to the bank's appeal to this court, and took an unusual course. The court, consisting initially of Neil LJ and myself, began to hear the appeal. They started to hear about forum. However, in the course of the argument, we drew counsel's attention to what appeared to be a jurisdictional bar to the plaintiff's claim, or at any rate the settled practice under the rules of private international law, that a personal representative who obtained probate or letters of administration of a foreign country could not be sued in that capacity in our courts. We referred counsel to a passage in Dicey and Morris I cite below, and then they resumed with 3 Lord Justices, including Lord Justice Bingham. And they then cite the law, which is then become Rule 133 of Dicey. And they conclude, after quoting in the middle of page 37 from the commentary, that the principle is reflected in other leading textbooks, see Salisbury's Laws, etc., etc. And then the rule on which the bank relies referred to many authorities in which the principle of Rule 133 has been recognised and applied. That's on page 38. They then refer to the authorities. And the conclusion one finds in the middle of page 39. Meanwhile, I conclude the principle of Rule 133 is settled law and subject to any applicable exceptions, the plaintiff's action must be stayed. So it was that point, it was suing Barclays as the foreign administrator of the relevant estate. Next, we also refer to Re Akilopoulos as to how the court approaches the question where the foreign estate is not an English system but a civil law system. How does one determine whether the heir is to be treated as an administrator or executor for these purposes? And that point arose for consideration in Re Akilopoulos, which concerned the administration of a Greek estate. And the conclusion one finds on page 14 in the highlighted passage. About 15 lines up. The problem raised by this summons is whether there is any distinction between a case where the principal is under the law of the domicile an executor, where the principal under the law of the domicile is not an executor, but only the person who, by virtue of his interest, is charged by the law of the domicile with the duties which under our law are imposed on the executor. For my part, I can see no distinction at all. It seems to me that all the court has to do is to satisfy itself that the principal is the person who, under the law of the domicile, is bound to perform the functions which are imposed on our law, by our law and upon an executor or administrator. In other words, that they are the persons who, under the law, are responsible for seeing that the debts are paid and the ultimate surplus gets into the proper hands. Now, that is the position of the heirs under civil law systems and is the position of Mrs. Safa in relation to the affairs of Mr. Safa, the late Mr. Safa, under the law of Lebanon.
Is that right? I didn't think the evidence did show that in this case.
Well,
there's no requirement to carry out executor-like duties.
there is a requirement because unless the duties are carried out, the estate cannot be distributed.
Cannot be.
It cannot be distributed. It's an inherent, it's a necessary part.
But there isn't a distribution.
Well, my lord.
As I understand the evidence, there's an automatic vesting of property in the heirs, and they are subject to various liabilities which may be limited in various ways. There's nothing corresponding to what Mr Justice Tomlin said in this case on 443, which is that under the law of Greece, it says those persons who are heirs are fixed by law with rights and duties corresponding with the rights and duties of an executor, including the duty to pay debts.
But the evidence is that under the law of Lebanon, there is no inheritance prior to the settling of the debts. Therefore, in order for the...
Sorry, I didn't read the evidence in that way.
Well,
the assets passed to the... I thought your own expert's evidence was that the assets do pass to the heirs automatically, and that there isn't a process of settlement of debts followed by the transfer of the assets.
the assets pass collectively to the heirs automatically by operation of law, as is typical in civil law systems. But under Lebanese law, the courts take the view that there's no inheritance prior to the debts being settled. That's distinct from the vesting of the legal rights in relation to the assets and the liabilities, the case may be. Lord, you'll find that, for example, said in a number of the experts' reports, but the letter by the Obaid partners, which was submitted by the Republic in relation to the application below. This is in supplementary bundle at tab 3, starting at page 52. and the relevant passage for these purposes is under section C on page 62, headed Limitation of Liability. At paragraph 45, as I noted above, the pecuniary debts of the deceased pass alongside his rights de jure to the heirs. However, this transfer comes with specific limitations. Payment of debts is limited to the value of the assets. Heirs are therefore only liable to the decedent's debt up to the value of the assets each heir receives. This structured approach ensures the heirs are not unfairly burdened beyond the value of what they inherit. And then at 46, in respect of liabilities, Lebanese courts and doctrine apply the principle there is no inheritance prior to the settling of the debt. This principle ensures that debts are settled before any distribution of the estate to the heirs. And then he refers to decisions of the Lebanese court in relation to that. The first is a court of appeal. Establishes a general principle in Lebanese law, the rights and obligations of deceased transfer in their entirety to the heirs. While there are no issues concerning transfer of rights, the transfer of obligations encounters practical difficulties arising from the possibility of the estate's debts surpassing its assets. Owing to the prevailing legal principle in Lebanon, rooted in both Islamic Sharia-based inheritance law and the inheritance law of non-Muslims, which stipulates that there is no inheritance prior to the settling of the debt. To summarise, the claim against the inheritance takes priority over the inheritor's rights, but only after settling deceased burial and funeral expenses.
But I thought that your own expert dealt with exactly that point and said it doesn't mean what it says.
Well, you didn't say...
In other words, it doesn't mean what it might literally be taken to say. And in fact, he takes issue with that and says that there is, in fact, an automatic process of succession. And so that concept of no inheritance until the debts are paid doesn't actually mean what we might think on the face of it means. And that certainly seems to be the way that the judge found it.
Well, my lord, it may be that, again, we're at cross purposes concerning this. But it's obviously common ground between the experts and clear that under Lebanese law that the debts and assets of the deceased, by operation of law, vest automatically in the heirs, subject to certain limitations. There is then discussion in the experts' reports, including in Mr Obeid's letter report, as to the extent to which heirs are able to deal with the assets prior to the settlement of debts. And to summarise some fairly complex evidence, it appears to be certainly said by one of the experts, or possibly common ground, that in relation to immovables, one needs to have a registration of some form before dealing. In relation to movables, the heir may be able to deal with the assets, but subject to the possibility that they may be, if they, for example, dispose of assets and there's a creditor whose claim exceeds the amount, they may have to make it good if they do it effectively at their own risk. However, it still remains the case that the principle described by Mr Obeid, which is there's no inheritance prior to settling debts, is an established principle of Lebanese law. And it may be that it states the overarching principle, which is that in practice there may be dealings, and maybe must be dealings in practice by the heirs of the affairs of the estate prior to the settlement of debts, but that nonetheless the debts must be settled before the heirs can be said to be entitled to inheritance. Now, where does that leave us in these circumstances? In our submission, it leaves us with the position that there is a process of administration. Indeed, there must be in Lebanon, as there is in every legal system that has any recognizable form of inheritance. And the process of administration must involve the tallying up, one way or another, of the assets and liabilities of the estate. Because unless that is done, one cannot know what the, I'm going to use the word estate interchangeably, I know it doesn't truly exist, but one cannot know what the state of affairs of the deceased are, what the ledger is. once that is done, it is possible to determine, firstly, what each heir is liable to receive, and secondly, the limit of the heir's liability to satisfy any creditors, because they're only liable to satisfy any creditors up to the amount of their inheritance. Now, it doesn't, in fact, matter for our purposes how Lebanese law approaches that question, whether it characterizes it as a process of inheritance or anything else, because the question of how one characterizes that activity is not a matter for the Lebanese court. Characterization for the purposes of the application of the rule in Dicey and Morris is a matter for the English court. And one finds that in the Viegas case, for example, where there's a discussion of it. This is at tab 16 of the authorities. At page 78, sorry, page 450, paragraph 78, I apologise.
Again, 450.
Page 450, paragraph 78. He deals with the topic of characterization. Again, this will probably be very familiar to court, but as explained in Dicey and Morris, the rules which have been evolved to deal with the choice of law problems are expressed in terms of juridical concepts or categories and localizing elements or connecting factors. Characterization involves determining which juridical concept or category is applicable to the relevant situation. If, to take an example given in Dicey, a person domiciled in England where a will is revoked by marriage makes a will disposing of land in Utopia, where marriage does not result in revocation and then marries, the answer to the question of whether the will is revoked could depend on whether the issue is characterized as one relating to succession or to matrimonial law. And then the question is, how does one characterize? And the answer is, characterization is carried out by the English court, the lex fori. One sees that, he refers then to Macmillan and Bishopsgate and Staunton LJ's judgment, and where he in turn quotes from then quotes from Auld LJ, a paragraph over the page, paragraph 80, and sees in the quotation above letter B, subject to what I shall say in a moment, characterization or classification is governed by the lex fori. Characterization or classification of what? Proper approach is to look beyond the formulation of the claim and identify, according to the rules of the lex fori, the true issue or issues thrown up by the claim of the defence. This requires a parallel exercise in classification of the relevant rule of law, the underlying principle of which is to strive for comity between competing legal systems, should not be constrained by particular notions or distinctions of domestic law of the lex fori, or that of the competing system of law which may have no counterpart in the other system. Nor should the issue be defined too narrowly so to attract a particular domestic rule under the lex fori, which may not be applicable under the other systems. Then he refers to Raferson case, 5-star trading, and Mance LJ. And convenient to refer to a 3-stage process. Does not follow the first stage, the court can or should ignore the effect of second stage of characterizing the issue in a particular way. The overall aim is to identify the most appropriate law to govern a particular issue. The classes or categories of issue which the law recognizes at the first stage are man-made, not natural. They have no inherent value beyond their purpose in assisting to select the most appropriate law. Mechanistic application without regard to the consequences would conflict with purpose which they were conceived. And then finally he refers to a pithy passage from Professor Briggs's book, Private International Law. The available categories are those created by the common law rules of private international law. The placing of the facts within one or more of them is done according to the reference to the same rules. For those who find analogies helpful, English law designs the pigeonholes, and English sorter decides which facts belong in which pigeonhole. So the starting point is to identify what the activity in question is to be characterized by the English court. And the question which arises here is, does the ascertainment of what liability should attach to the affairs of the late Mr Safa fall within the scope of succession or administration? That's the issue one needs to consider. And the answer to that is found also in Vegas, a little bit further on in the same decision, where New ELJ helpfully summarised a number of authorities to explain the dividing line between succession.
Can you just say what you say the situation or issue is again?
To determine whether, under Lebanese law, the liabilities that are alleged to have arisen between the Republic and the late Mr Safa attach to the affairs of Mr Safa, what one might call loosely his estate under the law of Lebanon. That's the issue.
I mean, actually, the issue is raised by the joinder particulars of claim, I think, is what is the extent of your client's liability for the acts of Mr Safa?
Yes, under Lebanese law.
Is that a fair way of putting it?
But what is the extent of...
Because it's to do with, under this substantive claim, the idea is that your client becomes liable by succession.
In her capacity as an heir to the affairs.
So the issue is, what is the extent, if any, of her liability to the Republic, isn't it?
With respect, my lord, I don't agree that that's the correct way to describe it. The issue is, to what extent does the alleged liability attach to the affairs of Mr Safa, for which my client may, under the law of Lebanon, be liable up to the limit of the assets of the affairs of Mr Safa that she has inherited. So it's a determination of tallying up the late Mr Safa's affairs, what are his assets and what are his liabilities, and do they include this alleged liability? That's the issue in carrying out that process. And the question to be asked is, does that fall within administration, which is not a matter for the English court, or succession? And the answer in our submission is that it plainly falls within the scope of the characterization of administration. And one can find that in the same judgment at page 463 of the bundle, paragraphs 118 to 120. Where New ELJ explains, under the heading analysis, there's no doubt that for the purposes of characterization, the law of England and Wales distinguishes between, on the one hand, the administration of an estate, and on the other, succession. And he deals with the succession of movables and so on and so forth. And at para 119, relying on the observations of Auld LJ and Macmillan and Mance LJ and Five Star Trading, Mr. Chuchoy has stressed characterization should not be constrained by particular notions or distinctions and be approached in a broad internationalist spirit. However, it's not apparent to me that the points of any real significance in deciding the scope of the administration of estates and succession categories in the present context. The evidence as to Brazilian law shows how another legal system approaches inheritance, but I do not see it casting any real light on where the English law should draw the line between administration of estates and succession. My lords and my lady, that's why I say that the debate about how precisely Lebanese law treats these things is in many respects a red herring. It's certainly a red herring for the purposes of characterization. And then he goes on to draw the line very clearly, again relying on previous clear authority in 120. In broad terms, it seems to be under the law of England and Wales, matters relating to the collection of a deceased person's assets and the payment of debts are considered to relate to the administration of estates, and the distribution of assets after that is considered to relate to succession. As Warrington LJ said in Ley Laurelard, it is only when the administration is over that the law of his domicile comes in. Likewise, Henderson J said in High Commissioner for Pakistan, it is only when one gets into the question of onto the question of succession and who is entitled beneficially to share in the estate that one looks at the law of the domicile of the deceased. And over the page at para 123, it says, if, as I consider to be the case, the collection of a deceased person's assets and payment of debts must be distinguished from distribution of assets after that, the question of whether the heirs have title to sue must, I think, fall to be treated as one relating to the administration of the deceased person's estate rather than one of succession. And then at the end of that same paragraph, 4 lines up, it's only when sharing is carried out that an heir obtains an individualised absolute interest in an asset which had belonged to the deceased person. It's only then, too, that in the eyes of the English court there's succession rather than the administration of estates. Now, that's clear authority on how one approaches the question of characterisation, and applying that to the present case, it follows that the matters asserted in the joinder particulars of claim, which is an assertion that a liability has attached to the affairs of Mr Safa for which the heirs or now heir are responsible, is a matter of administration, which is a matter exclusively within the jurisdiction of the Lebanese court. It therefore follows that there is no serious issue in relation to this claim. It's obviously a bad claim. The second point is this.
What do you say would be the issues? The Lebanese law evidence says that, first of all, that your client is the only heir now. That's common ground. The Lebanese law says that the heirs are responsible for the payment of the debts of the deceased up to the value of the assets. There may, in other cases, be questions about sharing the extent of liabilities, but that doesn't arise now because it's 100%. So what actually are the issues that you say might need to be determined?
Yes, the process of administration, the matters which constitute administration of the late Mr Safa's affairs, are the tallying up under the Lebanese system of the assets which are considered to be by the Lebanese courts included in his estate, and the liabilities which are said to attach to that estate. Again, so I'm using the word loosely, to his affairs. That process needs to be carried out in order to determine what, if anything, is left over for distribution to the heir. And that process, which is the bit before the sharing, is a process of administration. And it includes, necessarily as part of it, a decision as to whether the alleged liability to the Republic is a liability which forms part of Mr Safa's affairs and can be counted among the liabilities in his affairs in Lebanon. That's administration, squarely within administration. Now, my lords, there are a couple of further short arguments I should deal with that the respondent makes in relation to the serious issue to be tried. The first is that the respondent contends that Mr Justice Jacob in PIFs decided that the claim on the substantive basis was at least a good arguable case, and the Court of Appeal approved this. Now, this argument is based simply, in our submission, on a misreading of the relevant decisions. Starting with the first instance decision by Mr Justice Jacob in PIFs, you have that in the bundle of authorities at tab 18. And at paragraph 44, which is on page 484, Mr Justice Jacob deals with the two bases of argument, the enforcement basis or the substantive basis. And the first basis being relied on as a substantive basis. At paragraph 44, he says, "It seems to me the first route which Mr Norbury has relied on, namely that the court will be in a position to determine the heir's alleged joint and several liability, is by no means straightforward. I do not have to come to a final view on that particular route, and I decline to do so at the present stage. It does seem to me there's considerable force in the argument advanced by Mr Sherwin as summarised above, as to why it would be inappropriate for the court to decide the question of whether or not applying Swiss law, the heirs are jointly and severally liable. Mr Norbury's argument in that regard, if accepted, would seem to me to involve some departure from the approach which was taken in the Viegas case." And at paragraph 57, he says, "For these reasons, which essentially comprise Mr Norbury's second route, that's the enforcement, there's a good arguable case that the heirs are necessary or proper parties. They will therefore be joined. It will be open to Mr Norbury in due course to say that the first route is nevertheless available as well, and the court should therefore be imposing joint and several liability in the forthcoming trial on the heirs. That will be a matter to be argued in due course, and the heirs will no doubt, relying on Viegas, that the imposition of liability is inappropriate." Now, what is clear there is that for the purposes of considering whether the service out was justified, this being a set-aside motion, Jacobs J was careful to say, well, I accept that there's a good arguable case in relation to enforcement, but I don't accept or will not decide at this stage that there is in relation to substantive for the reasons he explained. So it is simply incorrect to suggest that Jacobs J concluded that there was a good arguable case in relation to the substantive basis. It got quite clear from paragraph 57 that he decided in relation to enforcement and declines to decide that in relation to substantive, leaving it open for the matter to be argued again at trial, should that arise. And similarly, in the Court of Appeal...
How would that work procedurally? Because on your argument, he hasn't given permission to serve out on that claim, on your interpretation of the judgment. So how could it be then argued at the trial? I'm a bit puzzled by that.
Well, it may not be a particularly practical approach, although it's pragmatic. But one assumes that what Jacobs J had in mind was that if he accepted that they're contrary to his initial view, that there was a good arguable case that service out could be effected on that basis, he would then either make an order for immediate service on that basis, or alternatively confirm that the existing service, which had already taken place, this being a set-aside case, could also be justified on the basis of the substantive claim. So what he was deciding in this case was that you've shown that you did have a basis for service out on the enforcement claim, so it's open to you to pursue that claim. But I haven't yet decided whether it's open to you to pursue the substantive claim. If you satisfy the court in due course that there is a good arguable case so that permission to serve out could have been granted, then I can consider the substantive claim.
So you think he's deferred the question of good arguable case
Yes,
to the
indeed.
trial? That's a rather unusual course, isn't it?
Possibly so.
Normally you decide good arguable case at the jurisdiction stage. Once you get to the trial, you're simply concerned with the merits of the case, as to which he's held that there is a serious issue to be tried.
Normally, that would be so, but it's clear that this is what he's done. One can see this from paragraph 57. For these reasons, there is a good arguable case that the heirs are necessary and proper parties. So he's saying definitively, yes, there is in relation to enforcement. And then he says, it will be open to Mr. Norbury to say the first route is nevertheless available as well. So he's deferring the question of whether the substantive route is a good arguable case to trial. It may well be because of the scale of the trial, which I think lasted the best part of a year. The learned judge was seeking to deal with matters in a pragmatic way. But he deferred that issue. And it's equally clear from the appeal, which is the next tab. Tab 19. at page 606. Having dealt with the enforcement basis and decided that the judge was right in relation to the enforcement basis, Lord Justice Arnold then turned to the respondent's notice, the substantive basis, at paragraph 37. And he said, counsel for the Al Rajan children's submission might have more traction with regard to substantive basis, because that basis involves Pierce claiming substantive relief against the Al Rajan children. But given my conclusion on the enforcement basis, it's not necessary to consider that question or the interesting arguments we received in relation to it. Now, we don't have the respondent's notice, but it wouldn't have been necessary for the claimants, Pierce, to serve a respondent's notice if they were not seeking to contend that Mr Justice Jacobs should have upheld permission to serve out on the substantive basis as well.
Well, I think there's a clue to it in 22.
I may have missed that, my lord. Thank you.
In the last sentence of 22, where
Yes.
Lord Justice Arnold more or less says
Oh,
that.
quite. Thank you, my lord. That answers the point I was trying to make. He does indeed say that, yes. Containing they should have held that Pips had a good arguable case, which necessarily shows that they accepted that he had not so held. And the Court of Appeal decided not to consider the point. So it's not the case either that the learned judge, Mr Justice Jacobs in that case, decided there was a good arguable case on the substantive basis, or that the Court of Appeal confirmed that. That's a misreading of the judgment. So there is no serious issue to be tried in relation to the substantive basis, but even if we're wrong about that, there's no gateway. There's no good arguable case that any of the gateways apply. The learned judge decided that in relation to this, the claimants could rely on the same gateways that were relied on as against Mr Safa, and you'll find that in his judgment in the core bundle at paragraph 42. That's page 94. Where he says, in my judgment, the claim against the respondents is the same as the claim against Mr Safa, and for that reason the same gateways apply.
I'm sorry, which paragraph?
This is paragraph 42 of the judgment.
Yes, thank you.
And the gateways he's referring to are the gateways listed at paragraph 39, which are three, which is considered separately, and that relates only to the enforcement basis. Can't relate to the substantive basis.
Why is that?
It can't
Could
relate
it
to
not relate to the substantive basis?
Well, the reasoning in relation to Gateway 3 is entirely different. The reasoning in relation to the application of Gateway 3 is there's a real issue between the parties as to whether Mr Safa is liable to the claimants, Mr Al Rajan, Piff's case, and that it's necessary to join the heirs to determine that issue, which is the liability as between the anchor defendant and the claimants. But in the substantive claim, the claim is a claim that the heirs are liable for Mr Safa's liabilities under Lebanese law, by operation of Lebanese law. It's an entirely different claim.
But isn't one of the elements of that that Mr Safa is liable to the claimant?
Maybe so, but that's not the same issue that arises as between the heirs and the claimants in relation to the heirs' liability for Mr Safa's liabilities.
No, but it is an element of it.
It is an element.
They can only be liable if he was liable.
That would only justify joining the heirs in relation to the first stage of the claim. It's also
Is there
necessary-
I'm so sorry, I interrupted you. Please carry on, sorry.
That would only justify service out of the heirs in relation to the first stage of the substantive claim.
But is
couldn't-
that the way it works, or is it enough if there is for the purposes of Gateway 3, if there is an overlapping issue, even if there are also separate issues which don't apply to the anchor defendant?
Well, it's well established that you cannot, that's the cause of action, the complete cause of action asserted in the joinder particulars of claim against the heir includes a number of elements. The first element is the assertion that there's liability as between the claimants and the late Mr Safa. The second element, however, is that on reliance on propositions of Lebanese law, that liability has fallen on the heir. It's well settled that you cannot obtain permission to serve out in relation to a cause of action that doesn't fall within one of the gateways. A necessary part of the cause of action and on the substantive basis against the heirs is the assertion that, based on Lebanese law, that they have inherited the liability of Mr Safa. And I should point out, in any event, I've already addressed Gateway 3 and the reasons why it can't apply, because of the lack of a real issue that exists. But in relation to the substantive claim, Lord, again, the point really arises from well-settled law about the way that the gateways work. You cannot use one, you can only get permission to serve out if you can show that your cause of action falls within one of the gateways, your cause of action entire. You cannot use one cause of action or one assertion as part of your cause of action to rely on a gateway in order to bring other causes of action which don't fall within a gateway. And that's the reason why, for example, if you seek to amend your claim to add a new cause of action, you have to justify that as falling within one of the gateways or permission will be refused. Each of them has to make its way to justify service out under the relevant jurisdictional rules. So turning to the gateways on which the learned judge relied, he dealt with Gateway 3, which I've already addressed, paragraph 43, but he decided that the requirements of one or more of the gateways are met, leaving aside for the moment Gateway 3.13, to which I turn separately. So the question is, does the substantive claim fall within any of the gateways identified, 4A, 6, 9, and 16? Now, these gateways are respectively, 4A is where a claim is made against a defendant, which, relevantly under C, falls within one or more paragraphs 1A, 2, 6, 16A, or 19 to 22A, and a further claim is made against the same defendant which arises out of the same or closely connected facts. And, my lords, if you have the white book, this is on page 331 of the 2026 edition.
I don't have a copy of that, but I'm just getting it up on screen.
I didn't detect that there was any issue on this one.
There isn't.
So maybe we can move on.
Similarly, Gateway 6 is in relation to claims in relation to contracts. It's a claim, essentially contracts connected in various ways with England, made within the jurisdiction, offer received within the jurisdiction, made through agent in the jurisdiction, governed by law of England and Wales. Now again, there's no claim against Mrs. Safa which depends on any English contract. The only claim as against her is that she has inherited a liability under various provisions of Lebanese law.
What
Gateway
was
6.
the basis on which Mr Safa was served under that gateway?
I'm not sure I can answer that, my lord, very clearly. There are a variety of claims asserted against the Prininvest companies. My reading of the main judgment is the contracts in question all concerned the Prininvest companies rather than Mr Safa personally, but I'm afraid I'm not in a position to answer that. Simply said to be one of the gateways relied on as against Mr Safa. But the problem with relying on the gateways as against Mr Safa is that they are not the gateways applicable as against Mrs. Safa. She's not been party to any contract that has anything to do with England. Gateway 9 is claims in tort. Again, she's not been involved in any torts committed or otherwise sustained in the jurisdiction. and gateway 16 is restitution, where the defendant's alleged liability arises out of acts committed within the jurisdiction, enrichment is obtained within the jurisdiction, or the claim is governed by the law of England and Wales. Again, it has no possible application to Mrs. Safa. So even if the substantive claim had a real prospect of success, there's no good arguable case that any of the gateways apply. Simply none exist to justify a claim against Mrs. Safa based on provisions of Lebanese law that she's inherited a liability, which is the nature of the claim.
Yes, well, one problem we have in relation to these gateways is the judge says, I think in one sentence, that they're available, but simply doesn't explain his reasoning at all.
Quite right, my lord. What he says is that the judgment, the claim against the response is the same as the claim against Mr. Safa. Well, it plainly isn't. It's a derivative claim. It's based on a proposition that Mr. Safa is liable, but that is not the claim against the heirs. They're not alleged to have done any of these things, to be involved in any torts or contracts. So it simply cannot be the case that one can rely blandly on the same gateways as against Mr. Safa and say they apply to the heir, because the claim against the heir is based on provisions of Lebanese law, to which no gateway applies. My lords, that concluded, subject to any questions you may have, my submissions, but my learned junior, Mr. Holden, was going to address you briefly on appropriate forum.
Very good. Thank you very much. Mr. Holden.
May it please your lordships and your ladyship, I follow Mr. Howe to address the forum issue, which, as you know, is the third aspect of the test. I think I can take it quite quickly, particularly in view of the time. Your lordships are familiar with the test. It is that the Republic, and the burden is on the Republic, must show that England and Wales is clearly and distinctly the most appropriate or proper forum for the determination of the claim. And in this context, the claim means the substantive basis claim, because as Mr. Howe submitted, we don't contend that if you're against us on our points on the enforcement basis claim otherwise, that England and Wales wouldn't be the appropriate forum for that claim. But we look for service out on a claim-by-claim basis, and the distinct substantive basis claim is the claim which we contend is not a claim which is subject to the English forum, and that the judge's reasoning in that regard is, with respect to him, plainly wrong.
For this purpose, are you proceeding on the basis that the substantive claim is a claim against your client for a money judgment or for some form of declaratory relief?
Well, it's an interesting question, my lord. If you look at the joinder particulars, which are in the core bundle at tab 9, and you turn to page...
I ask because I don't at the moment see how there could be a money judgment without knowing who the other creditors of the estate are or what the assets are, which at the moment the English court has no idea about at all. Although I can see it might be possible to fashion some sort of declaration.
Indeed, my lord, and it is one of our points as to why this court is not the appropriate forum for the determination of such issues. But if your lordship looks at the joinder particulars of claim, page 108, tab 9, what you won't find there, my lord, is a prayer for relief. You have a set of particulars pleading the liability of the heirs under Lebanese law, but what you don't have is a pleading of a prayer for declaration of any description. The remedies that are sought are not set out in the joinder particulars, and so eminent counsel have pleaded the joinder particulars. They seem to funnel the claim back to the main particulars of claim and the main claim form, because the only claim for relief remains in the claim form. You can see that at tab 8, and that is a claim for a money judgment against the corporate defendants, but also against Mr Safa. And so there doesn't seem to be a claim for a declaration as such. This is one of the reasons why we say there is no enforcement basis claim pleaded, because it's the essence of an enforcement basis claim. As Lord Justice Newgee said in the Piffs case, I'm sure you've looked at that section of the judgment, it's a pure declaratory claim, an enforcement basis claim. It's a claim for a declaration that the main defendant is liable, but that declaration is made against other parties so as to facilitate enforcement against them. That relief is not sought anywhere on the pleading as currently pleaded. What is sought is a money judgment. And I will come on to explain why we say England is not the appropriate forum to determine that issue. But if I can just show you briefly the judge's reasoning on forum in his judgment. It is at page 97 of the bundle, the core bundle. That's tab 6, my lord, my lady, starting at paragraph 57, and it runs over the page to paragraph 66. And so for these purposes, I would invite your lordships and your ladyships separately to read that section of the judgment. But if I can just summarise the judge's reasoning as to why he says England and Wales is the appropriate forum, really you find it at paragraphs 61 over the page, 63, and 64 to 65. And it's really one point, actually, although very eloquently put. It's that if the Safa parties, at that stage the 3 respondents, now the 1, are not joined as a party to the proceedings, there is a risk on the evidence that the English court's judgment will not be enforceable overseas. And paragraph 61, because the judge sees the present effort by Mozambique as enabling the English court in the circumstances described to complete its work in light of the sad development of Mr Safa's death, the importance of completing the court's work means that the judge doesn't want to leave the position unaddressed. So he asserts that the English court should take jurisdiction so as to render the English court's judgment more readily enforceable in other jurisdictions. And you can see that again in paragraph 64. The risk of the English court determining Mr Safa was liable only for the heirs to resist enforcement in Lebanon or elsewhere. And then...
Well, you would say that the reference to the English court completing its work goes to the enforcement basis, which you don't challenge for appropriate forum, but the English court would have completed its work when it had produced a binding judgment against Mr Safa if he had not died.
We do say that, and in fairness to the judge, this judgment is prior to, as you know, the judgment of the Court of Appeal in the Piffs case. And it really is there that Lord Justice Newgee clarifies this distinction. I can perhaps show you that in the authorities.
Can I just ask you a prior question before you do that? Because you're right, it's, if you like, clarified that. Supposing you've made a challenge to both the enforcement basis and the substantive basis. Now, supposing that you're right on the enforcement basis, this question of forum has to be decided on the basis that you're right about that. In other words, that your client isn't a party to hasn't been brought in and joined as a party to the English proceedings in order to be bound by the judgment. And so this question has to be addressed on that hypothesis, doesn't it?
Well, they are in the alternative, and service out has to be evaluated in respect of each claim. And so when your lordship is looking at the substantive basis claim, the question really is England and Wales the proper forum for the determination of that claim?
But if supposing that your client isn't brought in under the enforcement basis, so supposing you're right that that's not available, then when one comes to the substantive basis, one of the points the judge makes is that there's a risk of inconsistent judgments. That seems to be one of his principal points. Or looking at it another way, the risk that your client will then be able to say in Lebanon, well, I wasn't a party to those proceedings, they're not binding, I can start from scratch. And that seems to be the point he's making in 64, where he refers to the passage from the Commercial Bank of Dubai case. So am I right in saying that one has to approach this question through that prism?
Yes, in theory, but we make all of the same points on serious issue to be tried and on the gateways in relation to both claims. And so I'm struggling to see, my lord, how your lordships would reach the conclusion that the enforcement basis claim has failed to get through those hurdles, but the substantive basis claim has. And so the hypothesis that you raise doesn't arise.
Right, so essentially, a practical way of dealing with my point is to say you're not going to get to this claim on its own without the court also having found against you on the enforcement basis.
I think that must be right.
In that case, another scenario is that you fail on the enforcement basis, so that your client is going to be joined for the purpose of being bound for the purpose of enforcement, and as you're dealing with appropriate forum on the substantive basis, that only arises if there is an available gateway and if there is a serious issue to be tried. And once all that's got through, is there really a separate point left on appropriate forum?
Well, there is, because again, if that's the position, then the enforcement basis claim at that stage, the English court can take jurisdiction over it. We don't make a separate point on forum on the enforcement basis. So if we're in that situation, my lord, and you're against us on all of our other points, there is a claim in England available, the enforcement basis claim, and that is the claim that addresses the enforcement of this judgment in Lebanon. And so it's really, on forum, this is a reason why, if we reach this stage in the analysis, it's a reason why you should only give permission to serve out on the enforcement basis. And really, the short point on the judge's reasoning on forum, with respect to him, is that that's all he addresses. The only analysis he gives on forum is in relation to enforceability and the desirability of rendering the English court's judgment more enforceable overseas, Lebanon and elsewhere. He doesn't actually consider the separate claim on the substantive basis.
And if we were to accept that submission, what would be the practical consequence for the particulars of claim? It looks to me as if paragraph 10.4 would have to go, because that seems to be substantive rather than enforcement. What about paragraph 10.2?
Well, it depends on your view of my learned leader's submission that this claim, this pleading, does not plead the enforcement
No, I'm sorry.
basis at all,
I'm
but-
assuming for the moment. I appreciate there's all those things to go through, but assuming for the moment we were minded to allow the enforcement claim to proceed, but not the substantive claim, which I think was the submission
Indeed.
that you made.
Indeed, and that would be the effect in my submission if you're with me on the forum point. In that situation, 10.1 I think has become uncontroversial in the sense that the certificate has been issued and the appellant is the heir. 10.2 is the substantive basis claim. It's an assertion of Lebanese law of succession to assets and liabilities, and it needs to be read together with 10.4, which is that one of those relevant liabilities is the liability of Mr Safa to the Republic. And so the effect of the combination of 10.2 and 10.4 is that that liability by operation of Lebanese law now falls on the appellant. And those are the substantive basis claim. So if you're with me, those should be struck out or permission should not be given to serve them out of the jurisdiction.
Okay, now we've interrupted.
10.3 is okay, is it? 10.3 stands?
Well, 10.3 is part of the reasoning on the substantive basis claim. I'm working on my Lord's hypothesis that you
Yes.
think there is an enforcement basis claim in there, even though there's no prayer for relief in that regard.
If it's anywhere, it's in 10.3.
Well,
But maybe it's
more
maybe it's
eminent
not-
counsel
you'd
than
say
I
it's
have
not
pleaded
there.
it, but it's not a claim for a remedy. But there it is, it's
No.
10.3.
All right. Now we've interrupted you quite a lot. Do you have more to say, or are you coming to a close?
I've made my... It really is a short and single point that the judge does not analyse forum on the substantive basis claim at all. And on forum, on the substantive basis claim, it's a different law, Lebanese law. It has no factual connection with England. It has no legal connection with England. There are no witnesses in the jurisdiction. It really, the substantive basis claim, my lord, has no connection whatsoever with the English jurisdiction. And so if the judge approached it in a separate way, that is the inevitable conclusion in our respectful submission he should have reached. I won't labour the point more than that because it's not really more complicated than that. You also have the reference to the authority we've made in our skeleton argument, which supplements that. It's the Lambton decision on the importance of issues of foreign law like this being determined by the foreign court. But had the judge analysed this separate claim, we say he would have inevitably reached the conclusion that Lebanon is the appropriate forum. And his conclusion otherwise is plainly wrong. Those are the submissions on forum, unless I can assist your lordships or your ladyship.
Thank you very much indeed. All right, we'll resume at 2:05.
All right, table.